everyone, I'm Sarah Bloom, and today we're going to be doing a new Bloom Zoom segment called Can My Boss Do That? With my boss, Arick Fudali. So clearly this is not Lisa Bloom, although the resemblance is uncanny. This is Arick Fudali, the youngest managing attorney in Bloom firm history, an accomplished trial lawyer, and one-time commentator on Pix 11 News. Arick, am I missing anything?
You're missing a lot of things, but we can move on and go right into this. Hello, Sarah. Hello, everyone.
Okay, perfect. So today we're going to go over a few common scenarios we often come across in a new Bloom Zoom segment, Can My Boss Do That? So first scenario, during a Christmas party, Peggy's boss, Dan, gets drunk and tells her that he's always had a thing for her and asks her to come to his hotel room. Peggy politely turns him down. The next day at the office, Dan apologizes to Peggy. There are no other incidents of inappropriate behavior by Dan. However, since the Christmas party, Peggy has noticed that Dan has started assigning big projects to other employees. Can Peggy's boss do that, Arick?
It's a good question, Sarah, and it's a little more complicated than yes or no, so I'll break it down in two parts. Technically, it is okay for a boss to ask a fellow coworker or employee out on a date. I think that's inappropriate and I would advise against it, but technically that's not unlawful. Where it becomes unlawful is where we get what's called quid pro quo sexual harassment. And that is when a boss conditions a advancement in your career, a raise, or something along those lines on agreeing to a romantic or sexual relationship with the boss. That sounds like that's what happened here, and that is not okay.
And there's also a retaliation aspect to this, isn't there, Arick?
There is. So retaliation is when you, say, rebuff a boss's sexual advances or romantic advances, and the boss then retaliates or takes away certain good things about your employment. Now, retaliation is not always as black and white as the boss asks you out, you say no, and then the boss fires you. Often it's a bit more nuanced and it's a bit more subtle. For instance, maybe taking away larger opportunities, giving big projects to another employee as opposed to you. It's usually not as obvious as you would expect.
And as a side note, Christmas parties are never a good idea. We see this in a lot of potential cases where Christmas parties get out of hand. People are drunk, people feel empowered to confess their feelings. That's why Bloom from Christmas parties are very PG. There's a lot of children, 2-drink maximum. Keep it fun, keep it safe.
Bloom firm parties are great. I would advise all companies to follow the Bloom firm party model.
And that will be coming out with a patent for that shortly. Okay, scenario 2. Penelope notices that her boss, David, is having a consensual relationship with her coworker. The coworker gets the plum assignments and a promotion. The boss, David, makes no sexual comments to Penelope, nor does he hit on her. Arick, can Penelope's boss do that?
So technically, let's start again. It's a little more complicated. We'll break it down. Yes, a boss can have a consensual relationship with an employee, a consensual sexual relationship. Again, I would highly advise against it. I think it can be inappropriate and it certainly can lead to harassment and uncomfortable scenarios, but technically that's okay. Where it becomes not okay and unlawful is where what you call is sexual favoritism. It's not okay for a boss to show favoritism to the person who is engaged in a sexual romantic relationship with them. That also can then veer into quid pro quo sexual harassment as well.
That's right. So sexual favoritism is part quid pro quo, part hostile work environment for the other employees, correct?
That's absolutely correct. Well said.
Oh, thank you so much. Okay, so scenario 3. Patricia's boss, Dan, yells at her every day at the office. He calls her an idiot and makes her do low-level jobs like clean the bathroom that are not part of her job description. Dan treats many of the employees in the office this way. Can Patricia's boss do that? What do you think?
Unfortunately, yes. So there is no rules against the boss being a jerk. Again, I would advise against it, but a boss just being a jerk to everyone is not unlawful. Where it becomes unlawful is where, for instance, the names that are being called are a little more gendered, or the ridicule is a little more gendered. So imagine the scenario where the boss, instead of calling the female employee an idiot, says, "Wow, you're in a bad mood today. Is it that time of the month?" Or something along those lines, something that are specific to a gender, or for instance, more racially charged comments. The other way it could be harassment is if the boss only treats, say, the female employees, only calls the female employees idiots, only lashes out at the female employees, or perhaps a specific minority or race of employees. That's where it becomes harassment and inappropriate.
Okay, great. So our last scenario 4.
Phoebe's boss, Damien.
Why are all the names P's and D's, if you don't mind?
Because it's plaintiff and defendant. It's very clever. You're welcome.
That is very clever, Sarah, and very law schoolish of you. I'm very impressed. Okay.
Thank you so much.
Moving on to scenario 4. Phoebe's boss, Damien, frequently shows inappropriate material at the office. He comes to her desk and pulls up pornography on her computer and prints out pictures of naked women and leaves them on her desk. Damien has never said anything inappropriate to Phoebe, nor has he hit on her. Can Phoebe's boss do that?
The short answer is no, and I'll explain. Common misconception is that sexual harassment is either verbal or physical, but there is a third form of sexual harassment, and that is visual. Visual sexual harassment, as you just described, Sarah, is showing pornography, showing obscene things, showing obscene writings, or writing obscene notes, that type of thing. So showing pornography or anything close to it in an office is absolutely inappropriate and is absolutely a form of sexual harassment.
In fact, Arick and I had a case last year where the clients allege one of the forms of harassment was the boss put up pornography on office computers, on a projector, and also frequently posted obscene photos on his Instagram account, which he forced them to follow. And we argue that that was also a form of sexual harassment.
I would add that the jury agreed that was a form of sexual harassment, and we won that trial and got an $11 million verdict for our clients. Is that correct, Sarah?
That's correct. And I think now worth over $12 million with attorney's fees. Okay, so that's all from us. Thanks for tuning in, everyone. Of course, every case is very different and every case is much more complicated than just a few short sentences. So if you think your rights have been violated, you should contact an employment lawyer like the Bloom firm immediately. To contact us, go to our website. Arick, what's our website?
That is thebloomfirm.com.
Until next time, stay strong and stay safe.